those of you who are just joining us, we'll go live and get started in about 60 seconds, just 1 minute. We'll wait for people to file in. Okay, welcome everybody. Welcome to the Shenkman Private Client Group Accountant Attorney Fall Webinar Series. This program is entitled Revisiting the Secure Act, Planning Strategies to Discuss with Your Clients. For those of you who don't know me, my name is Jonathan Shenkman, and I'm a financial advisor, portfolio manager, and an accredited investment fiduciary at Oppenheimer based in New York City. The goal of all my programs is to bring professionals together to better help them serve their clients. This is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between a client's attorney, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not-for-profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. In addition to the 10 to 15 events I run every year, I also do a fair amount of writing on topics of investing and financial planning. You could read my work in Barron's, Forbes, Kiplinger, the Wall Street Journal, the CPA Journal, Trust and Estates Magazine, and many other periodicals. My most recent piece was published in Forbes entitled 5 Crucial Planning Steps to Take Before You Retire. After the program, I'll send out a link to this article and a variety of other periodicals where I publish my work. Today, we are privileged to hear from Avery Neumark from the accounting firm Marks Paneth and Bruce Steiner from the law firm Kleinberg Kaplan, both based in New York City. I will give both Bruce and Avery an opportunity to share a bit more about themselves and their respective practices in just a moment. But first, by way of introduction, the Secure Act was approved by the Senate on December 19th, 2019, and signed into law on December 20th. This far-reaching bill includes significant provisions aimed at increasing access to tax-advantaged accounts and preventing older Americans from outliving their assets. Today, we'll explore some of the key takeaways for advisors to help them better serve their clients. Before we jump into the meat of the presentation, I'd love if our speakers can each introduce themselves. Please speak a little bit about your background, describe your practice area, and how you work with clients. Bruce, why don't you start us off?
So I'm a lawyer. I do tax, wills, trusts, and estates at Kleinberg Kaplan, Wolf & Cohen. And over the years, a larger share of what I've been doing has been in the area of planning for retirement benefits. I've written extensively on that. You can find the articles on my bio. If you Google my name and Kleinberg Kaplan, it'll come up to the top of your hits, and then you can scroll down and see some of the articles that I've written. But I do the full range of tax and trust and estates, everything from planning, administration, estate and trust disputes, getting private letter rulings, getting permission to make what would otherwise be late elections, GST exemption, allocation planning, tax planning for business transactions, and everything else related.
Great, thank you. And Avery, please tell us a bit about your background, practice area, and how you work with clients.
Morning. I think I got dressed up for the occasion here today. I see Jonathan and Bruce are in their informal home working outfits, so I feel a little overdressed, but it's great to be here.
You look great.
Thank you. I'm a partner at the accounting firm of Marks Paneth. We have offices here in the city, in New York City. I'm living in Manhattan, so when I say here in the city, that's where I am. And we have offices in Long Island and Westchester, Washington, Philadelphia, and a few Jersey. We're a regional firm. I believe we do everything that the Big Four do at double the quality and half the fees. I'm basically a practitioner in the tax department in the benefits area, employee benefits, executive compensation, anything related to that, distributions, the related estate and the trust issues that come with pensions. I deal with the IRS and the Department of Labor, contact with them and issues that come up with pension plans. The firm does a good number of audits of 401k plans and defined benefit plans, the audits that are required by the DOL when you have 100 more participants. My background is I am a JD, I have a law degree, an LL.M, a master's in tax, and also a CPA. I've spent my whole career in tax departments at CPA firms. So I take that angle and work with Bruce and lawyers because we don't do the drafting of documents. So Bruce and I have worked together on matters that we have common clients on. And Jonathan, we have clients at Oppenheimer, and we have mutual referrals as well. So that's basically my background, and specializing in employee benefits, executive comp, and anything related, Social Security issues, insurance issues, and anything medical issues, medical plans, health and welfare plans, anything with tax aspects to it.
Great. Avery, let's stick with you for just a minute. Can you give us a brief overview of the Secure Act? What is it and why it's important?
Okay. Basically, you said a little before, Jonathan, the Secure Act is part of a larger act which was signed by the president in late December. The Secure Act is part of the Further Consolidated Appropriations Act of 2020. That's the name of the act, even though it was signed in December of 2019. And people asking, why is it called the Secure Act? Secure is an acronym for Setting Every Community Up for Retirement Enhancement Act. And it happens to be the most comprehensive retirement reform package since 2006. We in the pension business and the employee benefits business, for the past few years, there wasn't so much legislation in our area, but suddenly the Secure Act, and what I'll talk about in a second, has changed the front of our practice now, and these changes affect employers, participants, individuals, employees, plan administrators. As Jonathan mentioned, there are a lot of provisions here affecting IRAs, affecting distributions, affecting plan filings, multiple employer plan issues, extending ages of required minimum distributions, which we'll talk about, time of adoption of plan, disclosures to participants about lifetime income disclosures and other requirements, stretch IRAs, which we'll talk about, and other 529 plans. There were some changes in 529 plans and other provisions in this act. But this wasn't the end of it. We thought at that time the Secure Act was the end of it. We had enough to do. And suddenly, as you know, we were all hit with the pandemic. And on March 27th of 2020, the CARES Act was signed into the law. The CARES Act has its own provisions, which I believe will be a separate seminar, but there are a number of provisions, 3 or 4 provisions in the CARES Act, which dovetail on what we're going to speak about today. And once again, the acronym for CARES Act is the Coronavirus Aid, Relief, and Economic Security Act. And that also covers certain provisions regarding minimum distributions and distributions, special distributions, and loans from IRAs and plans. Thanks.
Thanks for the overview. Just as a programming note for the audience, we're going to start off with some basic concepts, then quickly work our way up to more sophisticated planning strategies. So just bear with us if you know some of these basic concepts already. Bruce, how do IRAs work, and what is the difference between a Roth and a traditional IRA?
So IRAs are incredibly powerful because the income and gains within the IRA are tax-free. And they're tax-free for a very long time, not as long as before the Secure Act, but nevertheless, they can be tax-free for a very, very, very long time. The difference between the traditional and the Roth is that the traditional is part yours and part the government's, and the Roth is all yours. Let's say I'm in a 30% tax bracket forever, and I get a $1,000 bonus, and I put it into a traditional, and that money is 700 of it is mine, and 300 of it is the government's. That's the tax I would have paid if I put it in my pocket. But if I didn't make the contribution, the 700 in, let's say I put $1,000 into the traditional, and over time Jonathan invests the money for me and it grows to $10,000, and I pull it out and I get to keep 7 and I give the government 3. So that traditional IRA was at all times 70% mine and 30% the government's. If I didn't make the contribution, I would have $700 in my pocket, and I would have paid the government $300. That 700 would not grow to 7,000 because every year I'd have to pay tax on what it earned. So it's basically a tax-free income and gains within the IRA. A Roth is really the same thing. It's just bigger because it's all yours. And for people who can't afford to maximize, who can't afford to put in the maximum amount, it's just a play on tax brackets. But for people who can afford to put in the maximum amount, a Roth is just bigger because it's all yours from day one. So that's the difference between the traditional and the Roth. The traditional is part the government's. Every time you pull out money, the government gets its share. And the Roth, when you pull out money, it's all yours.
Great. Avery, are people justified to be concerned that the Roth IRA tax advantages may be changed?
And to answer that, Jonathan, I'll give a commercial for your future seminar on what's going to happen at the election and what could happen with a new tax bill, which Jonathan will tell you when that session is. But this has been a discussion. I don't have a client that doesn't ask this question. They're nervous because one day the Roth rules may be repealed, and then they'll be taxable. The amounts contributed may be taxable, or the earnings may be taxable. There's so many different scenarios that can happen. I can only give you my personal opinion, and Bruce, feel free to chime in as well. Right now, you have Roth IRAs. Right now, you have the rules that Bruce talked about. You have the rules about Roth IRAs, about where it's all yours. You don't share it with the government. We'll talk about conversions later on. I believe, or let's put it like this, I can't believe that if there's a change in the rules regarding Roth IRAs, that it will be made retroactively. I think it would only be prospectively, in some way eliminating the advantages of Roth IRAs. But those that have already contributed to Roth IRAs or on their way with Roth IRAs, I personally can't believe there'll be changes in the tax treatment of that. And the history shows when there are changes, even now, as we'll discuss later with stretch IRAs, if they were done before an effective date, the rules didn't change. So that's my personal opinion. So I tell people, if you want to do a Roth IRA, do it. And right now, there's only talk. There's no specific legislation out there. So my feelings do it.
Bruce, when would you want to contribute or convert to a Roth IRA?
So there are lots and lots of benefits to the Roth, and a contribution or a conversion is really the same thing. The short answer is if you can contribute or convert at a tax rate that's lower than, equal to, or not too much higher than the tax rate that would otherwise apply to the distributions. If everything else were equal, it would be equal, lesser or equal to, but there are so many other benefits of the Roth. You've got more money in the tax-free environment. It's a better vehicle for allocating GST exemptions. You've got more money protected from creditors, and so on and so on and so on. So if you can contribute or convert at a tax rate that's less than, equal to, or somewhat higher, but not too much higher than the rate that would otherwise apply to the distributions, especially if you have other money with which to pay the tax rather than having to tap the IRA itself to pay the tax. It's often substantially beneficial, far more often than most people realize.
Great. Avery, can inherited IRAs be converted to Roth IRAs?
Answer is that an inherited IRA cannot be converted to a Roth IRA. As we'll discuss, I think Bruce will discuss later, if the spouse inherits an IRA, that spouse can make that IRA his or her own and then possibly convert it. But in general, an inherited IRA cannot be converted to a Roth.
Bruce, first question with the word Secure Act in it. How did the Secure Act change the required beginning date, and what opportunities does that provide?
So the required beginning date, that was when you had to start taking your money out. The general rule was at age 70 and a half, with the first year's required distribution, you could defer it until April 1 of the second year, and then you'd have to double up in year 2. And the Secure Act substituted the number 72 for the number 70 and a half. So everybody gets either 1 or 2 extra years before they have to start taking distributions. The opportunity there is you have, first of all, you have more deferral because you have another 1 or 2 years where the money can stay in there. And the other is you have 1 or 2 more years of potentially being in a lower tax bracket and being able to do more Roth conversions at lower tax brackets. So that's another opportunity for lots of people.
Avery, are life expectancy tables expected to change?
There has been proposals that the life expectancy, the IRS has put out proposed new life expectancy tables, but they're not part of the Secure Act. The present life expectancy tables which we have been around for a long time. And statistics show that life expectancies have been expanded or longer, that's the word. And so the new proposed tables show that, reflect that. But it was not part of the Secure Act. And, but it is believed that sometime in 2021, they may be finalized and we will be using those tables. But right now they're in proposed form. We use the old tables as of now until they become finalized.
Bruce, did the Secure Act allow persons over 70 and a half to contribute to traditional IRAs, and what opportunities does that provide? And feel free to offer any illustration or anecdotes.
So it does. The rule previous to now was that you couldn't contribute to a traditional after 70 and a half, and there were income limits on contributing to a Roth. So there were people who were just not allowed to make contributions. That age cap has been eliminated, so anybody, regardless of age, who has appropriate earnings or her spouse does, may contribute to a traditional. So that will allow some number of people to make contributions, either deductible if they qualify for a deductible, or if they can't deduct it, they can contribute and then do Roth conversions. If they don't have any other traditional IRAs, then they can do the conversion without any tax consequences. So for some people, it will be helpful.
Avery, do QCDs still qualify at age 70 and a half?
Okay, so what is a QCD? Let's start there. A QCD is a qualified charitable distribution. And this came into law a number of years ago. And for a number of years, the QCDs were on hold and put back in the last day of the year or towards the end of the year. It allows somebody to make a charitable contribution from their IRA directly to a charity of up to $100,000. They do not include that amount in income. They do not include that amount in income, nor that, of course, they don't get the deduction either. But there's an advantage to this, that it goes straight, transferred from the IRA to the charity. And the fact that they don't include it in income is better, because many times the charitable deduction may be limited by itemized rules and so on. So it's an advantage to do that, and also part of your required minimum distribution can be used for this QCD. It can only be made by people who are age 70 and a half, and literally 70 and a half. Not the year you're 70 and a half if you're not 70 and a half yet. It has to be literally age 70 and a half. And this question came up that Jonathan asked because Bruce just mentioned that the minimum distributions would change from 70 and a half to 72. So people are asking, are the qualified charitable deductions also, is QCD changed to age 72? The answer is no, it has not changed. You're still eligible to make this charitable contribution at age 70 and a half from an IRA, even though you're not required to take a required minimum distribution. So there are 2 points here. One point is that if somebody's charitably inclined, they can do it. And there are many reasons, both from tax and estate tax purposes, why one may want to make a charitable contribution from an IRA. And secondly, the IRS just the other day came out with a new notice. It was issued September 2nd, 2020. It's notice 2020-68. And it's some guidance on some of the retirement provisions in the Secure Act, the Secure Act. And it addresses some issues and doesn't address other issues. I guess some future guidance will come out on that as other issues. But it did talk about what, it did mention what Bruce just mentioned about delaying the required distributions from 72 to 70 and a half. But it also mentioned about making traditional IRA contributions after 70 and a half, and its interaction with QCDs. And it talks about, it gives an example in the notice of how making a deductible traditional IRA contribution past 70 and a half can result, if you also do a QCD, in making part of the QCD partially or wholly taxable. So there is interaction. It's a little complicated. There's interaction if you make a deductible IRA contribution post 70 after the same year you do a QCD, speak to one of us because there is some technical rules that you're going to have to follow that may reduce the full benefit of the QCD. But in general, if you don't make a contribution, deductible contribution, QCDs are fine, and in many cases, they're very advantageous.
Thank you. Bruce, how does planning change now that the Secure Act generally limits the stretch to 10 years? And what are the exceptions to the 10-year rule?
So I'm gonna invert the order and deal with the exceptions first. So the exceptions are for people who count as eligible designated beneficiaries, spouses, the IRA owners, minor children, not somebody else's minor children, not your minor grandchildren, but your own children, people who are disabled, and the definition of disabled is almost identical to the Social Security definition of disabled. So it's a pretty safe bet that if you've been determined disabled for Social Security, you qualify here, although there's an awful lot of people who are disabled and never got Social Security because they didn't have enough work, years of work, or because their parent didn't reach the age at which the parent could get Social Security and they could tag along. Chronically ill, which is has its own definition. It's geared to the long-term care insurance definition, or somebody who's not more than 10 years younger than the IRA owner, which would largely be a sibling, although it could be anybody who's within 10 years. And those people still get the old stretch, at least while they're alive, and then for 10 years after they die, or in the case of the minor, when the minor reaches majority. How does planning change? Well, for most people, planning stays about the same as it was. Some people might try to have eligible designated beneficiaries as their beneficiaries to get the stretch, although that's not always practical. We're going to see more Roth conversions. Why? Because in the past, when the beneficiaries got a very long stretch, you didn't bunch the income. If somebody got $1 million IRA and it was payable over 50 years, in year one, it was $20,000 and so on and so on. And if it was a smaller IRA, it would be even less each year. But now it has to come out within 10 years. So the income will be bunched into higher tax brackets. Or if it's payable to a trust, the trustee has to choose between accumulating the money and paying tax at a high rate, or distributing the money and losing the asset protection. A Roth conversion avoids all of that. So even if under the old law, your tax rate might have been a little higher than the rate that would have applied to the distributions, it may be now that your tax rate is now lower than what would be on the distributions. So more Roth conversions might make sense. I think that's the biggest change. We may see more people provide for their spouses in trust rather than outright, especially in second marriages, where you had this big trade-off between the benefit of the spousal rollover on the one hand versus the benefit of having control on the other hand. Or maybe a spouse, you were just concerned about the spouse's ability to handle the money. And you may have weighed and balanced it and come out on the side of leaving it outright for the tax benefit. The tax benefit of the rollover isn't quite as much as it was before, because after the spouse's death, it's probably going to have to come out within 10 years. So you might leave it to the spouse in a conduit trust, where in the past sort of conduit trusts almost never made sense, and here's a time when you may see more of them. So there's a few little changes at the margins. For most people, I think the planning will be similar to where it was before, with maybe a little more in the Roth conversions.
Avery, what is the once per year IRA rollover rule?
Once that, this is gotten a lot of play in the last few months, the once per year rollover rule. This rule came in as a result of a case, and most probably about 5 years ago, the rule came in where you can only make one rollover from an IRA to the same IRA or another IRA in any 12-month period, regardless of how many IRAs you own. And a typical example, people were playing the game, they would take money, they needed money for a short period of time. They would take money out of their IRA, roll it back into the IRA within 60 days, then take it out again, roll it back again within 60 days, and they would keep doing that as a way to get short-term money and still not have to include it in tax. So the once per year rule, the one rollover per year rule was enacted. Now, this is from IRA to IRA, and it does apply in aggregate to IRAs and Roth IRAs. So if you have both types of IRAs, you're still limited to one 60-day rollover in the 12-month period. Now, the 12-month period is an issue because the 12-month period isn't a calendar year. The 12-month period applies on a 365-day basis. So it starts with the date you receive the funds that you rolled over, and then you count from there. But in certain cases, and we get this often, the one rollover per year rule does not apply. So it doesn't apply, for example, for rollovers from plans, a qualified plan like a 401k to an IRA, or an IRA to a plan, or a plan-to-plan rollover, or what we would call trustee-to-trustee transfers from the trustee, where it doesn't really go through the hands of the IRA holder where he can use the funds. And also, it doesn't apply to Roth conversions. So if you convert, that's not considered a violation of the once per year rollover rule. Now, if you violate it, it's serious, because then you may have to include the amounts as taxable income and possibly the excise tax penalty depending on your age. So the once per year rollover has to be adhered to and be very careful about it. I'm going to add one thing which we'll talk about in a few minutes. The reason this has become very publicized lately is because of the CARES Act. When we talk in a few minutes about the CARES Act, about the waiver of minimum distributions in 2020, I'll come back and explain why the once per year rollover question has become a major question in 2020.
Bruce, let's talk about trusts. I know we have a lot of estate planning folks on the webinar today, and this is probably what they've been waiting for. What is the difference between a conduit and accumulation trust, and when does each type make sense?
So our clients almost always provide for their beneficiaries in trust rather than outright, to keep their inheritance out of their estate and to protect against their creditors and spouses. And the same reasons for leaving other assets in trust apply to IRAs. A conduit trust requires that all the distributions out of the IRA into the trust have to in turn be paid out from the trust to the beneficiary of the trust. So pre-Secure Act, they almost never made sense because you blew your asset protection. You might as well just leave it outright. It really had no purpose other than if you provided for a spouse that way, the required distributions out of the IRA were slightly less because you got to recalculate the spouse's life expectancy every year. So occasionally you did it a conduit trust for a spouse. Accumulation trust should really have been called a discretionary trust. The trustees get to decide what to distribute and when to distribute, and that provides much more flexibility, much more asset protection at the cost of the tax rates on trusts tend to be higher than the tax rates on individuals. Under the Secure Act, some people who left their IRAs to spouses outright might leave them to the spouse in a conduit trust because it gets you a little bit of protection over the money and you're giving up the rollover, but the rollover isn't as valuable as it was before. You might do a conduit trust for your minor child to get the stretch until the child reaches majority, which includes until they finish their education, but not beyond 26. So let's say it gets you till 26, and then the 10-year rule applies. But on the other hand, that means that at 18 or 21 or 25, the minor, it means at some point, it means at 36, the minor gets control. Whereas if you did a discretionary trust, you could protect it forever at the cost of having to draw down the IRA within 10 years. Conceivably, you could do it for an eligible designated beneficiary. In the case of a disabled or chronically ill, you can get the best of both worlds. You can have a discretionary trust and get the life expectancy stretch. So conduits really have very limited application. The big problem is people who sort of did conduits under prior law when they shouldn't have. It wasn't the end of the world in the early years because the distributions were small. In the later years, of course, the distributions were big, but the drafting lawyer would probably be dead by that point. And now the whole thing comes out in 10 years. So you'd have a real disaster if you needed the protection of the trust. So people who drafted them under prior law should review them to see whether they should change that now.
Bruce, another question about trusts. How and when can you use a charitable remainder trust to replicate the stretch, and how does it work?
So the charitable remainder trust.
I see that one got you excited.
Well, it is. I've written 2 articles about it. One is in Kleinberg, which is a paid service, but I encourage everyone to subscribe to it. Go to kleinbergservices.com, and no, I don't get a commission if you subscribe. And the other is in the April issue of Trust and Estates, and that we have posted online. If you Google Bruce Steiner, Kleinberg Kaplan, it'll come up to the top of your hits, and then it'll be the top article because we show the articles from newest to oldest, so it'll be the very top one. A charitable remainder trust is a trust that is itself tax exempt. So it can collect the entire IRA all at once, and then it pays, I'll put income in quotes, to a person, usually for life, and then at the end, whatever's left goes to charities. So, and the payouts have to be at least 5% a year, and the value of the charity's interest from day one has to be at actuarially 10% of the initial value of the IRA going into the trust. So it's like a 10% tax. You leave $1 million IRA into this trust, and the present value actuarially of the payments year by year to the child are worth $900,000, and the present value actuarially of what the charity gets is $100,000. It doesn't mean that the charity will get $100,000. It gets whatever happens to be left. So the child has to be or grandchild has to be at least 27 for you to be able to do it. So it works. And it replicates the stretch because the child is getting at 27, you get about a 5% payout every year, and you revalue the trust every year. So you get 5% of whatever the trust is worth year by year. If the child is older than that or grandchild, you can have a payout that's a little higher than 5%. The older you are, the higher the payout rate. So it works best for people, for children or grandchildren who are relatively young, but at least 27, people who are going to need distributions anyway, and people who don't expect to have taxable estates. If they're going to have taxable estates, you wouldn't want to throw more money into their estates. But truth be told, that's most people. Most people are going to need some distributions, and most people aren't going to have taxable estates, even if it reverts to 5 million, probably even if it reverts to 3.5 million. Remember, in 2001, when the exemption was $675,000, only 2% of estates actually paid estate tax, and at 5 million or 11 million, it's minuscule. People who aren't really concerned about creditors or divorces. Most people really aren't concerned about creditors other than spouses. Divorces is the issue, because in 3/4 of the states, gifts and inheritances are not in the pot for equitable distribution, although they may or may not be considered for alimony and child support. But if those aren't major concerns, it's a wonderful, wonderful way to replicate the stretch. You have to make sure that there's some other money available for one-off needs, because the trust, unlike a discretionary trust where you can pay out more in the year where more is needed, the formula is fixed from day one. It's the payout is that payout which qualifies, which results in the present value of the charity's interest being 10%. So you need some other assets. The other risk is if you've got a beneficiary who's supporting a family and the beneficiary dies early, the family loses out on all that money, but you can replace that with a life insurance policy that spans the time from the IRA owner's death until when the beneficiary is either no longer supporting other people or has enough other money to support those other people. So that's usually pretty manageable. If the beneficiary is healthy, you can go buy the policy the day the IRA owner dies. So it's a very, very powerful technique, and I think for people who have children or grandchildren in their high 20s, 30s, 40s, maybe even a little beyond that, your family is better off that way than if you just left it to them directly, and it had to be paid out over 10 years. And even if it comes out even, so charity gets a lot of the government's money at no cost to you. So I urge people in the right circumstances to consider that.
Great. Avery, is there any intersection between the Secure Act and the CARES Act? If so, what are some key points worth highlighting?
There are a number of things I'd like to mention before I get to that answer. Okay, I just want to go back to the new notice that I'll get to your questions. I want to get to that new notice that just came out, IRS notice 2020-68, which I talked about before on the qualified charitable distribution. We talked before about the Secure Act allowing post-age 70.5 contributions to traditional IRAs. Now, the notice mentions, and this is interesting to you, Jonathan, as well, that financial institutions do not have to accept post-age 70.5 contributions. This is a very interesting notice. However, if the financial institution chooses to accept post-age 70.5 contributions, it has to amend its contracts the IRA language and all the language on the back of the paper, by December 31, 2022, and notify these individuals of the amendment 30 days after the amendment is adopted or becomes effective, whichever is later. So I think that's interesting. Also, the notice clarifies that an individual's post 70.5 contributions may not be used to offset RMDs, required minimum distributions. So, for example, if somebody's making a post 70.5 contribution to an IRA and he's age 73, he can't offset his RMD, which he's required to take at age 73, with the contribution he's making, because contributions and distributions are separate transactions. So I think we're going to see a little play on this as well. That's one. Two, I think a underlying concept, and Bruce, feel free to help me on this. I think the most important concept of everything we are talking about today is that you have, number one, the proper beneficiary designation, that you understand who the beneficiary of your IRA or of your 401k plan, of your plan is, and you understand the tax ramifications, whether it's a spouse or a non-spouse or an estate or a charity. You understand the different tax ramifications, advantages and disadvantages of that, one. And two, how it plays with your total estate plan. Very important. The last part of the beneficiary designation is to make sure it's there. To make sure it's there. People, number one, you ask them when you're talking of your tax planning and estate planning, who your beneficiary is. I don't know. I forget. Or I think it's my spouse, but I don't remember. Do you have your beneficiary designation form? Well, I did it 30 years ago with Manufacturers Hanover Trust, and that merged to this firm, and that merged to that firm, and that merged to this firm. And suddenly you can't find it, and the bank can't find it, the custodian can't find it, the brokerage can't find it, it's lost. And if you don't have a valid beneficiary designation, there could be consequences, tax consequences for that as well. So it's so important to make sure your beneficiary designations also are correct, and in light of Secure and the CARES Act, they're updated as well. So it doesn't hurt to visit Jonathan or Bruce or myself and discuss this and make sure your beneficiaries, just as if you would have an updated will, an updated trust, you should have updated beneficiary designations, because the other point is that IRAs and 401k plans are similar to life insurance policies. They pass outside of the will, and it's not necessarily the same beneficiaries as the will, and we can address that in more detail, I guess, another time. The CARES Act is very interesting. So the CARES Act has 3 or 4 provisions that affect us. And the most important one is that it waives the required minimum distributions for 2020. I guess a break with the pandemic, with the way the market was going, businesses are going, we got a break. So required minimum distributions from IRAs, from qualified plans, are waived. Also inherited IRAs, Roth IRAs, all waived for 2020. So, of course, a lot of questions came up about this. And one of the most popular questions that came up is, since this waiver notice came out in March, the CARES Act came out in March, what happens if I took my required minimum distribution already the beginning of the year, the beginning of 2020, and I didn't have to? Can I put it back? Or what other planning tools are there? So the answer is, we went back in history. I think it was the Katrina and some other disasters where the IRS did provide restoration of distributions taken which didn't have to be taken. So yes, you had until August 31st to put back any required minimum distributions you already took out in 2020. You can restore it.
It's too late.
Now it's too late, but you had until August 31st. Now I'll come back to that in a minute. Now, how do we, two questions, Bruce. How does this tie in to what we said before about the once per year rollover? Because we've had clients, and many times, Jonathan, you know, required minimum distributions for people over age 70, or 72 are paid out monthly. Some people got their minimum distributions. They got a 12th in January, a 12th in February, a 12th in March, and so on. Now, can they roll all those back? Or are they violating the once per year rollover rule? So the IRS notice said, we waived the once per year rollover rule as long as you got it in by August 31. So that was one thing. So where's the planning now? Where's the planning now? There are a couple of plans. And Bruce, please help. One, if you didn't take a required minimum distribution yet for 2020, you don't have to. You don't have to. Because the issue is sometimes they're automatically paid out from the custodian. And if you don't tell them you don't want it, you're going to get it. Now, even if you get it, at this point, you still have 60 days to roll it back. So the 60-day rule still applies to distributions you didn't get or distributions you got after July 1st, say. So say you got July, oh no, well, today's September 10th. So if you got a distribution July 20th, you still have till September 20th to put it back. Because you still have even though the August 31st for more than 60 days deadline is gone, you still have the regular 60-day deadline to do it, to roll over. So that's one. So any distributions past July 10th, you still have time to do. Number two, you still can let your custodian know you don't want your distribution this year. And three, like you mentioned, Bruce, and I know you're smiling, you can take your required minimum distribution, don't give it back, and what will you do with it? You may want to, take it, pay the tax, use it, and if your income is low this year, and use it, can you convert it? Can you convert it to a Roth? Possibly. Or use it as a Roth IRA, contribute to a Roth IRA with that money this year.
Avery, I don't mean to jump in, but I see we have like a ton of questions from the audience.
Right.
So I want to make sure that we hit some of them. And both you or Bruce and Avery could feel free to jump in on the question. So I didn't mean to cut you off, but I want to make sure before time's up, we hit some of these. So I'll jump right in. Stephen from New York asked, is it an option for a non-spouse beneficiary of an IRA to wait the full 10 years before taking distributions, or do they need to take a distribution every year? And feel whoever wants to jump in.
They can take it at the end of 10 years. As Bruce mentioned before, there's planning. If you want to take it over the 10 years or a certain amount during the 10 years, you can wait till the end of the 10 years. There's no required amount like 1/10, 1/10, 1/10.
Bruce, anything to add, or that covers it?
No, next.
Ronald from Tampa asked, please describe teapot and balancing trust as a technique to circumvent the negative aspects of the new 10-year rule. I think that's for Bruce.
So it would be somebody from Tampa, because Alan Gassman from Clearwater, which is right next to Tampa, wrote an article on it. He basically says that with the money coming out over 10 years, and you could have one child in a high bracket, one child in a low bracket, why not have the IRA go into a sprinkle trust for the family, and have other assets go into a different sprinkle trust from the family, and then you could distribute the IRA money to the low bracket people and other assets to the higher bracket people. I think it's an interesting concept. It's a little bit of extra complexity, but it's interesting.
Okay, I don't know how familiar people are with some of those concepts, but we could leave it there, I guess. Jeffrey from Morristown, New Jersey asks, are there philanthropic planning opportunities opened up by the Secure and CARES Act? I think we touched on some of them, but.
Yeah, we did. More charity, more charitable remainder trust.
And PCDs.
Okay.
PCDs are still at 70.5.
Okay, 1 second, let's see.
You can never give enough charity.
Bruce from New York asks, what happens when a beneficiary of someone who died before the Secure Act dies?
10 years. The 10-year rule kicks in.
Okay, simple enough. Okay, Lewis from New York asks, should individuals over age 90 consider rolling IRA funds into a Roth IRA if it's not needed to live on, particularly 2020 RMDs, but possibly more if doing so doesn't push them into a higher bracket? Lewis also indicated that this is for a client who's married, filing jointly with grown children who also don't need the funds to live on.
This is the answer I was talking about when you cut me off, Jonathan.
Sorry.
No, just kidding.
My bad.
No. This is exactly the answer. Sure.
The answer is yes.
Yeah, the answer is yes. But the 2020 RMD, don't forget 2020 RMD is a misnomer, because there is no RMD in 2020. But the answer is yes.
Okay.
Absolutely. Yeah.
Anne from Arizona asked, are there suggested drafting changes around trusts designed to receive retirement assets?
Pretty much the same as before. Maybe some conduits for spouses and conduits for other people generally didn't make sense before and generally make less sense now. And the rest is about the same.
Okay. And the final question that I have here is Lindsay from Minnesota. Can you talk specifically about the impact on lower income clients?
More Roths.
You want to elaborate at all on that, or?
Well, the beneficiaries will get the distributions bunched into 10 years, and you've got the IRA owner in a low bracket, so perfect opportunity to do some Roths.
This is the time also, the other commercial for your election session. The rates are low now, and this is the time to do it.
Okay. Before we wrap up, and we'll wrap up in 1 minute, do either Bruce or Avery, do you have anything that you'd like to add that you felt like we missed, or that you could that you wanted to add before we wrap up the session? Any other important items related to the Secure Act?
Unless do you want to cover the write-in questions?
Those were
the only two you should know that there are special distributions, corona-related distributions from plans and IRAs that one can take if they're an affected individual, if they had a coronavirus or their family, if they lost their job. You can take distributions from a from an IRA up to 100,000 or from a plan up to 100,000. And there are repayment provisions and tax provisions which make it easier to use the money, and you don't have to pay, you can pay the taxes over 3 years. Also, if you're part of a 401k plan, the loans are increased if you're an affected individual as well. So just keep that in mind in coordination between the Secure and the CARES Act.
Okay. Bruce, anything you want to add specifically, or?
Well, I think I would respond to some of the write-in questions. So Linda asked if a beneficiary is a minor, you would name a custodian under the Uniform Transfers to Minors Act, and if you didn't, you would hope to persuade the financial institution holding the IRA to let it go to a custodian. Douglas asked about sub-trusts. I'm not sure what a sub-trust is, but you could have as many trusts as you want, and if an IRA ends up going to different trusts, the trustees of each trust can do whatever they want with their share of it.
Okay, great. Well, thank you both.
And asked about the RMD from the CARES Act. The answer is yes, if you're an affected individual. If you're an affected individual, then you can de facto use that RMD and pay it back over the 3 years. But you got to be an affected individual according to the definition.
And if you take money out using that provision, remember you've taken money out of your IRA, and it was tax favored while it was in there. So you should consider whether you should do it sort of if you need the money.
Right.
Great. Thank you, Bruce and Avery. I want to be respectful of people's time. But if anyone has any specific questions, new business opportunities, any other issues they'd like to discuss, please feel free to reach out directly to Avery, Bruce, or myself where appropriate. I'll be sure to include their contact information in the follow-up email to this program. As I mentioned at the onset, the goal of these programs is to stay up to date on timely wealth management related topics and to collaborate where appropriate. I think we can all agree that the clients who are best prepared are the ones who are served by a team of knowledgeable advisors. One more item before I let you go. My next program is October 19th at 8:30 a.m. and is entitled What Your Estate Plan Isn't Doing, featuring Matthew Rappaport, who is Vice Managing Partner of the law firm Falcon Rappaport and Berkman. You will be receiving an email tomorrow morning with more details and registration information for this and all my upcoming programs, and I hope you can attend. And with that, this concludes today's session. Please stay safe, healthy, and have a happy and healthy new year for those who are celebrating. Have a good day, everybody.